An audit of special indemnities. The following presentation provides a summary of this report. As the nonpartisan independent auditor of the Legislative Assembly, the Auditor General audits the government reporting entity. This consists of ministries, crown corporations, and other government organizations such as universities, colleges, school districts, health authorities, and similar organizations that are controlled by or accountable to the provincial government. The Office of the Auditor General serves the people of British Columbia and their elected representatives by conducting independent audits and advising on how well government is managing its responsibilities and resources. Under the Auditor General Act, the Auditor General conducts and reports on both financial audits and performance or value for money audits. In most Canadian jurisdictions, public servants are provided with legal assistance and financial protection for legal proceedings that may arise out of or in the course of their employment. The BC government provides indemnity protection to its employees as part of their terms and conditions of employment. For the purpose of this report, a special indemnity is an agreement under Section 72 of the Financial Administration Act in which the government chooses to cover an individual's legal costs for circumstances beyond the scope of government's existing indemnity policy. We carried out this audit to determine whether special indemnities were granted, administered, and reported in a consistent and transparent manner, and whether the terms and conditions of the indemnity agreements were complied with. We based our audit objectives and criteria on the Financial Administration Act, the Guarantees and Indemnities Regulation, the Public Service Agency Indemnity Policy, indemnity provisions in collective agreements, indemnity policies from other Canadian jurisdictions, and principles of administrative fairness. We expected to have access to all of the files and the ability to choose our own sample from those files to be representative of the range of circumstances covered. Due to solicitor-client privilege, the Auditor General could only access those files where indemnified individuals provided a waiver of their solicitor-client privilege. Solicitor-client privilege is the confidentiality privilege that exists between the indemnified individual and his or her lawyer. As a result, we had access to 26 special indemnity agreements, which were not representative of all of the different types of proceedings covered through special indemnities. For instance, there were no examples of indemnities granted to cover the cost of legal counsel for witnesses in public inquiry proceedings or respondents in conflict of interest proceedings. Because we had access only to indemnities where individuals had waived solicitor-client privilege, we were unable to conclude on 2 of our 3 objectives. Specifically, we were unable to conclude whether our findings regarding the administration and funding of the 26 indemnities we reviewed were representative of all special indemnity files. However, we were able to conclude on our 3rd objective that reporting of special indemnities does not provide sufficient information to the Legislative Assembly on the obligations assumed and the expenditures incurred under special indemnities. First, let's look at the administration of special indemnity files. All the indemnities we reviewed had been approved and/or amended in compliance with the applicable legislation. Government provides indemnities on the presumption that an employee has acted in good faith unless evidence exists to suggest otherwise. For criminal matters, determining whether an employee's conduct was in good faith is left to the courts to decide, and eligibility is based solely on whether the matter arose from the individual's performance of employment. Although the issue of good faith is considered in the decision to grant a special indemnity, we found no evidence in the 26 files that we examined to indicate that government had made any effort to confirm good faith once the proceedings had concluded, regardless of the outcome. Given that the issue of good faith is central to public interest, government should, at the conclusion of the proceeding, revisit the issue of whether an employee acted in good faith. The report makes 4 recommendations concerning the administration of special indemnity agreements. Since 2001, indemnity agreements included a provision that the total amount funded under the special indemnity could be made public once the proceedings were complete. However, there has never been a provision in the agreements requiring the records themselves be made available for audit once the proceedings were complete. As a condition of receiving government finance legal advice, a term should be included that requires individuals to waive solicitor-client privilege for the purpose of audit. This term would enhance the transparency of the indemnity practice and would not be unprecedented. For example, the Legal Services Society, which provides legal aid in British Columbia, already requires clients to waive solicitor-client privilege for audit purposes. Regarding the management of legal costs funded under special indemnity agreements, we found that 5 of the 26 files contained invoices where information was insufficient to determine if the services were in compliance with the scope and terms of the indemnity agreement. When the Ministry of Justice contracts with private counsel, rates are usually negotiated according to a ministry fee schedule that sets hourly rates based on the lawyer's number of years of experience. Higher rates cannot be paid without written approval of the Assistant Deputy Attorney General. In practice, it is difficult to adhere to this fee schedule where the lawyer being retained under a special indemnity has previously negotiated a higher rate with the Ministry of Justice for other matters, or where the lawyer is aware of the ministry paying rates that exceed the fee schedule. The rates paid to private counsel varied from file to file, and each rate was negotiated separately by Legal Services Branch. It is unclear from the files how the rates were determined. We made 3 recommendations about how government manages the legal costs funded under special indemnities. Government's efforts to manage publicly funded defense costs require balancing a responsibility to the legal process with a responsibility to the taxpayer. In the case of an indemnity for a criminal investigation or trial, where government is funding both the prosecution and the defense, the tension between respecting the legal process and respecting fiscal stewardship increases. The appointment of an external manager for special indemnities for criminal matters would establish greater separation between defense cost management and prosecution cost management, remove any appearance of conflict of interest, and make it easier to enforce maximum cost amounts and hourly rates without appearing to be influencing the defense. Finally, let's look at reporting as it relates to special indemnities. The approval of a special indemnity under the authority of the Financial Administration Act creates a statutory obligation for government to pay approved legal representation costs. It is difficult to budget for the costs of special indemnities as there is no certainty regarding the length of the proceedings or the legal costs required to resolve a matter. Voted appropriations establish a set annual spending maximum. A special account provides flexibility as unspent balances can be carried forward to the following year. Consequently, most costs related to special indemnities have historically been funded through the insurance and risk management account rather than a voted appropriation. To date, there has been no reporting of the costs of individual special indemnities to the Legislative Assembly. The report makes 3 recommendations in the area of reporting: to improve accountability for costs incurred under the new indemnity regulation, as well as to ensure consistency in how government accounts for employee-related costs. Government should consider a model where costs are charged to a voted appropriation. There is currently no annual reporting of indemnity costs that satisfies the requirements of the Financial Administration Act. The costs incurred under special indemnities are included in the public accounts each fiscal year, but not in a discrete statement as required by Section 74-3. As a result, members of the Legislative Assembly and the public are not able to understand the annual cost of special indemnities or the total cost of each special indemnity. That concludes our summary of this report. To read this report and our other publications, or for more information about our office, please visit our website at www.bcauditor.com. The Office of the Auditor General encourages your feedback on this report, as well as your suggestions for further audits.